In case you haven't noticed, this country is being invaded by illegal immigrants. Right after taking office, President Biden rolled back virtually every policy of President Trump regarding asylum, deportation, basically destroyed the regime created by President Trump that gave us the lowest number of illegal crossings in this country in 30 or 40 years at the end of 2020. Now, every week, we're setting new records. Why? The policies that existed during the Trump administration worked. They're being reversed by President Biden, and we're being overwhelmed, and the worst is yet to come. If the Biden administration, the CDC, does away with the ability to deport illegal immigrants under Title 42 of the Public Health Law, presenting a threat to COVID, then you will see the numbers go up even further, and there will be thousands, 18 to 20,000 people a day coming across our border from countries with low vaccination rates. So when it comes to illegal immigration, policy matters. When Judge Jackson was a district court judge, there was a case brought by Make the Road New York et al. Versus McAleen, who was the acting DHS secretary under President Trump. The group, Make the Road New York, was an Arbella activist group. This is a kind of a holding company, for lack of a better word, an umbrella group funded by George Soros and a bunch of other liberal billionaires. This group, in that chain, receiving money from these folks, filed a lawsuit arguing that the Trump decision to deport under expedited immigration authority people who've been here 2 years or less, to change Obama policy and actually fully implement the authority given to the DHS secretary, they decided to go to full 2 years. Anybody here 2 years and under in the category in question could be deported with expedited procedure, meaning it was a quick turnaround. This was the authority given by the Congress to the DHS director. Obama didn't use that authority fully. Trump decided to do it. Make the Road New York et al., a bunch of liberal groups, sued the Trump policy change. Judge Jackson was the judge, and she overruled the Trump decision, and the statute in question said that the secretary has the sole and unreviewable discretion to use expedited deportation for people 2 years or less. This statute could not have been written any clearer. And if you're looking for what an activist judge is all about, this is the case, Exhibit A. The law was written in the most clear terms, saying the decision of the secretary is unreviewable and solely in their hands when it comes to using expedited removal procedures for people here 2 years or less. She ruled against the Trump administration, and she basically said this was arbitrary and capricious. It reeks of bad faith, showed contempt for the authority that the Constitution's framers have vested in the judicial branch. That contempt she's talking about was a congressional act. The congressional act was designed to tell judges that the DHS secretary has discretion in this area, solely and unreviewable. She found that concept offensive. So instead of it following the plain letter of the law, she did legal gymnastics to find against the Trump administration. And when she said the statute created contempt for the authority that the Constitution's framers have vested in the judicial branch, what she's saying, I'll be damned if I'm going to be limited by a congressional act that tells me I can't do what I want to do. And the plaintiff in that case was from the radical left, and she ruled for them in spite of the plain meaning of the statute, and she was overturned by the D.C. Circuit Court. The court said, and this is a fairly liberal court, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms, heralds Congress's judgment to commit the decision exclusively to agency discretion. She ignored the plain meaning of the statute, the language of the statute, to get a result she wanted, and the D.C. District Court of Appeals said that there could hardly be a more definitive expression of congressional intent. That is judicial activism on steroids, and it makes managing our immigration problem even worse when you have activist judges that ignore the law, take discretion away given by Congress to the executive branch because they don't like the outcome. That is, in fact, the premier definition of judicial activism. And I find in her judging a desire to get an outcome, and no matter what she has to do to get that outcome, she will pursue it. And this is a case where you couldn't have written a statute more clear, and she just went around it, got the result she wanted, and slapped down on appeal.